statistics and the information they provide is terrific. One of the things you find in ICSID is, of course, that privacy or secrecy, if you will, that you find in other arbitration centers, to a large extent, because of the nature of disputes, because countries are involved and there are public policy matters, is to a large extent diminished. It doesn't disappear entirely, but at least when a case has been filed. Some hearings can be open to the public, some awards in principle are available to the public, etc., etc. So that provides transparency that again goes within the nature of the types of disputes that are settled within ICSID. So for that, I would say ICSID needs to be the place of choice when it comes to investment disputes, because it's basically their business, as opposed to other arbitration places that eventually can handle commercial disputes or other types of legal disputes that do not necessarily involve investment and do not necessarily involve states. Now, ICSID has some issues, I think. I mentioned some, other people can have others. In terms of, for example, the way the procedures are, how long the procedures can be. The process of appointment of arbitrators, for example, has been one of the things criticized. For example, the use of the list. I personally, this is public, I've mentioned this in different places and have written about this. ICSID publishes statistics every year, and if you see the statistics, the number of Latin American cases, or cases involving Latin American states, is around 40-something%. When you look at the percentage of arbitrators from Latin American states, that percentage is around 15%. Of course, the parties are not compelled to choose arbitrators as per nationality, etc. And not only they are not compelled to use the list, but there is Article 38 in some of the ICSID Convention. There are situations under which the Secretary or the President or the Secretary General can appoint the arbitrators. The question I have, and it doesn't show in the statistics, and I've mentioned this to McKinnon, who is a good friend. In the statistics, you don't see if that percentage, the 15%, comprises also the times ICSID has used Article 38. She told me that she thinks it's less than 15%. So that's one thing that probably can trigger criticism. Why? Because countries, again, going to the legitimacy issue, countries would like to have arbitrators that, in principle, if they are appointed by ICSID or in the cases when that happens, at least are people knowledgeable of the Latin American reality and the legal system, etc. So there are other issues we can go on. For example, the annulment, the lack of appeal, which is something that has been discussed in the past, of appeal mechanisms, etc., etc. Now, ICSID has, to me, one of the best things I can, and I already mentioned that when I referred to the Salini criteria. ICSID has, because of its nature, ICSID was created, and if you read the preamble and documents of the executive directors, etc., you'll see, and there has been some awards in that direction, others against, of course, but you'll see that ICSID was created by countries because they were looking for a way to attract foreign investments as a way to promote development. Now, under the Salini criteria, there are some, again, going within the precedent issue of ICSID, there are some tribunals that follow the Salini criteria, there are some tribunals that don't follow the Salini criteria. The Salini criteria has been, it was a case, the Salini case, and in that case, the tribunal basically set up the criteria that were supposed to be satisfied by investors in order to be considered ICSID investments. What some people call the outer limit of jurisdiction, and some people call the inner limit. The outer limit being that determined by the ICSID Convention, and the inner limit being that determined eventually by the relevant treaty, that be a BIT or whatever, an FTA with an investment center. If you go to Article 25, then according to the Salini criteria, there are some factors that need to be satisfied, and most tribunals apparently concur. You know, at least in the 2 or 3 of them, you know, there needs to be the investment needs to be for long term. There needs to be, of course, capital, etc., etc. But the last one has been the last criteria, the one related to economic development, is the one where many tribunals, even tribunals that follow part of Salini, have come to the conclusion, well, yeah, economic development could be a good thing, but it's difficult to prove, or economic development, you know, it can be part of another element. What some people think is that economic development is key to the definition of investment, of an ICSID investment. Why? Because otherwise you could be in a position that an investment that is detrimental to economic development, for example, against human rights, or an investment that was purported through corruption, or, for example, against the environment, etc., will be also entitled to ICSID protection. And according to people that followed that point, that was not the rationale of the policymakers, the people that made the ICSID Convention. The ICSID Convention was made in order to protect foreign investments, yes, but foreign investments, whenever they are beneficial to economic development. Again, that part, there has been, as I mentioned, some tribunals that don't follow that, etc., etc. But that's a possibility that you have within ICSID. That's a possibility that has been presented by many countries as part of a defense during the objection to the jurisdiction. And if that defense succeeds, but the result could be eventually that the claim could be dismissed at that stage of jurisdiction. That is a possibility that is not available, as I mentioned, under other mechanisms. In Latin America, you're seeing that, of course, investors are choosing International Chamber of Commerce, or going to ONCITRAL, there is even Stockholm cases, etc., etc., etc. And there has been some wording about the possibility of setting up Latin American arbitration centers under the UNASUR and the ALBA. I understand there has been some discussions about the possibility of setting either centers or tribunals. And there has been even here in Washington, under the sponsorship of the Inter-American Development Bank, discussions about the possibility of having, similar to what the WTO has, the advisory facility, an advisory facility for investment disputes, which would be used eventually by countries that are affected, you know, by the cost and the length, etc., of these procedures. As I understand, that advisory facility would be just an advisory facility, not an arbitration center. And countries that has participated in that are basically countries that have bilateral investment treaties or free trade agreement with investment chapters with the U.S. So basically Mexico, Chile, Uruguay, etc., Peru, etc. But that's information so far. So in a nutshell, I would say, you know, that I think ICSID, we're going to see more of ICSID. There was some years ago a paper about changes on ICSID, 2 or 3 years ago, about the possibility of improving. I think some changes were implemented internally. Some changes could not be implemented because they require changes in the convention, which is a big thing. But I think probably, you know, the momentum is right for additional changes that could be in tone with what is happening, and probably satisfy some of the differences that is going on.
Ignacio, I know that you just jumped in. If you could just fit into your answer.
Yeah, I agree with your point. It's that issue of ICSID itself about arbitration, and that takes me to the point I raised before. Yes, the system of international protection of foreign investment requires a neutral mechanism, to say neutral international mechanism